On the record in the matter of the people of the city of Lansing versus Rambo L, file numbers 22L2761882, 881, and 883. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Buckle up, guys, because today's courtroom chaos features a sovereign citizen and a self-proclaimed insane defendant all in one saga. We open with Ronald Harav's attorney asking to withdraw, citing a complete breakdown in communication. The judge listens carefully, but it's clear this is more than just a disagreement hits. The prelude to a legal standoff where two entirely different realities are about to collide.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. This is when it went unanswered. I would like the court to dismiss this matter.
Okay, your motion to dismiss is denied.
From the moment Harav drops the wild trustee of my Cest KV account claim, you know we're in for sovereign rhetoric overload. The judge tries steering the hearing back to reality. But Harav's fixation on fringe legal theories keeps pulling it off course. Eventually, he reluctantly agrees to keep an attorney, though not without making it obvious he's still chasing. Answers the court has no intention of giving.
How many days does the prosecutor have to answer my motion for demand for motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties? How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
The judge patiently outlines how a new attorney will be assigned, warning Harav that if he burns through another one, he'll likely have to go it alone. Harav pushes for answers the judge can't provide. Then the case takes a procedural turn with the announcement that a new judge will be taking over soon, effectively resetting the stage for Harav's next round of sovereign argument.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court, neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied, is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James Version, Luke 11:52, as well as some other articles and treaties.
Asterisk, asterisk. Judge Hesselink steps in and wastes no time addressing the plea deal on the table. But Harav can't resist reviving his trustee theory, claiming vague precedent backs him up. The judge listens calmly, presses for actual proof, and remains unfazed by the pseudo-legal jargon. As Harav struggles to back up his claims, the tension grows. This is a battle of patience versus persistence.
Nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will
Well,
set your matter.
I like to challenge jurisdiction right now. I have the right to
You can file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible. Okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just we don't have it. I don't know why we only have one motion. That we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm going to set both of these matters for hearing, though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're going to file it in writing and you're going to serve it properly on the parties that you're filing it against. Okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? Okay, well, then you're all set. Thank you.
Asterisk, asterisk, when pressed for evidence. Harav admits all he has is belief. He pivots to complaining about a $1,000 license reinstatement fee he insists should have restored his license. The judge firmly explains that's a matter for the Secretary of State, not the court, drawing a clear line between court authority and administrative action. It's a textbook moment where belief slams into the brick wall of legal reality.
You can have a seat. Thank you. Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records, please?
Oh, you want to call him? Let me.
Oh, I'm sorry.
Swear, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth?
So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. I the document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late for my son's banquet.
Asterisk, the judge returns to the plea deal discussion, but Harav shifts gears, accusing the court of bias, demanding fine adjustments, and then suddenly declaring insanity. The room hangs in awkward silence before the judge wraps things up, leaving the insanity plea dangling. It's the perfect storm of confusion, deflection, and legal derailment all in under 2 minutes.
And I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. Earl, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across the
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
Yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence, because when you file a motion, you got to get a hearing date for that motion. And so
who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And ask for hearing dates for your motion?
And I asked when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they said,
And you do have a hearing date, but that's not.
like them ordered for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court, because I don't have a copy. You can make it now orally.
Okay, well, now comes the beneficiary for Rambo L, defendant in error, here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer Zinderbar. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff lacks jurisdiction, personal confirmed jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship now.
Asterisk, asterisk, next. We meet Quentin Brown, who missed his earlier arraignment but insists on representing himself. The judge warns him about the dangers, urging him to reconsider. But Brown doubles down, complaining about plea deals being discussed without him. It's the age-old courtroom clash confidence without experience meeting the reality of judicial authority. If you enjoyed this breakdown, don't forget to like the video and subscribe to the channel, and we'll see you in the next one.
Authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785. We find United States government as a foreign corporation with respect to the states. Since the corporation is fictitious, a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, a liaison, some sort of connection to a fictional person. Constitutional Amendment Number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, in effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons, things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I ask for a jury. Case number 2. I have the right to travel freely and unencumbered pursuant to Shapiro versus Thomas, 394 USP 618. That right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously perverted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything. Says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with immunity. Case number 5, Marbury versus Madison, 5 U.S. 137, shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262, says I may ignore the license and the fee and engage with the right with immunity. That means you can't punish me. And United States versus Bishop defines willfulness as an evil motive or intent to avoid a known duty task under the law with a morality certain. I submit I couldn't have been doing an evil task. I totally followed the Constitution in the Supreme Court. Bryers versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respect to those who were designated to safeguard the liberty and security of a citizen in regards to both persons and property. See Note 31, Bryers versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power using